Well, hello there. Thanks for joining me. I am Dr. Jen, and this is my life as a landlord. I'm so pleased that you joined me for today's show. Today, we are exploring the location-specific tenancy guidelines for Washington, D.C., that is the District of Columbia. In all of my location-specific episodes, I've included hyperlinks to lots and lots of resources for wherever we are studying, which today is Washington, D.C. And today's show notes, I have 6 hyperlinks. I'm going to share screen shortly, and we're going to go through all of them, looking at the same 4 questions that I look at in all of my location-specific episodes. And those are, 1, what are the basics of the tenancy laws of wherever we are looking for, or wherever we're looking at, which in this case is the District of Columbia Tenant Bill of Rights. 2, what are the nuances of this location? What's different? What stands out? 3, what's some guidance about abandoned items left behind by a tenant in Washington, D.C.? And 4, where to get help in your local area. And then at the very end of this episode, I'll go through what I call my bingo card, which is my list of the most standard items I see when I do these location-specific episodes. And I'll review what's there, what's missing, what's extra, what's different. And I have to, of course, give you the big disclaimer that there may be more guiding documents, more items than what I'm giving you here. This is not everything. This will just get you started and give you some guidance, but there may be other things in your state, district, wherever you are, or wherever your rentals are, like registering your rental, or maybe you need to be licensed. You're not, who knows? And even if I get it 100% right 5 minutes after I record this episode, it could change. So please just know that this episode is not all inclusive. You must research further to get the most updated and accurate items for where your rentals are located. Give a shout out to Aloha Capital Investments LLC for today's sponsorship. If you want to know what Mike and I are up to, or you want to be a part of it, check out alohajv.com. Okay, so let's, let's go into sharing screen. So if you are on YouTube at My Life as a Landlord, this is going to be the easiest one for you. Otherwise, I'm going to dictate some of this. I'm not going to explain everything, and I'm certainly not going to read it all. Where are we? Share. We want to share this one. Okay, so if you look, I've got the first hyperlink pulled up, and it's Code Council, District of Columbia. And this is, remember, when we're talking about tenancy law, it is a law. So this is the law part of tenancy stuff for District of Columbia. Okay, so there's a lot of this, and we can look at some of these hyperlinks. There's probably 50 hyperlinks here. Landlord's lead for rent, how it's enforced, service of notice of quit, notice to be recalled. Let's just keep going. I mean, there's a bunch. Lots of legalese here. I'm just going to click one of these hyperlinks. Let's see what happens. It goes down into the actual statute, and looks like it was just updated 2 weeks ago. So pretty cool. So this is, again, it's talking about leases and covenants and conditions for all of this, but this will at least get you started. And the resource talks about all kinds of things, right? Tenancy at will, tenancy by sufferance. What is tenancy by sufferance? May be terminated at any time by notice from the landlord to the tenant to quit the premises leased. Let's see, 30th day after the service of such notice. Yeah, so and then, this is kind of cool. It has these cross-references. Those cross-reference alterations to unit after notice to vacate, prohibition, meaning you can't take a sledgehammer to the place. You're not supposed to do that anyway. Cool, okay. Let's see, recovery of real and personal property leased together. Oh, this is interesting. So whenever real and personal property are leased together, for an example, a house with furniture contained therein, like if you're going to rent something furnished long-term, then it talks about summary proceedings. Okay, summary proceeding for possession. Okay, well, so that makes sense. Oh, here we go. This is one of my main tenants. Here we go. Disposal of tenant's property upon ejectment or eviction. I guess they call it ejectment in Washington, D.C. At the time of an ejectment, not subject to Chapter 35 of this title. Now, I do not know that, but that part is highlighted. That's the hyperlink, so I'll leave it there for now. The landlord shall change the locks on the leased premises in the presence of the United States Marshal Service at the landlord's expense and take legal possession of the leased premises by receipt of document from the marshals. So any right of the ejected tenant to redeem the tenancy shall be extinguished at the time of the ejection, which means they've lost possession of the unit, which makes sense. Any personal property remaining in or about the leased premises at the time of ejectment is deemed abandoned, correct? And then the landlord shall dispose of any abandoned property in a manner not prohibited by Section E of this section, otherwise expressly prohibited by law. And so then it talks about selling. Typically, when we're talking about abandoned property for a tenancy, there's typically an amount of time that you're supposed to store or inventory or do your best as a landlord to get a hold of the tenant, even if you know they're incarcerated or they're in the hospital or something like that, or maybe they've fled the country. I mean, there's all kinds of reasons why people abandon their place. They just leave, and so there's usually a timeline. And so I'm not seeing any of the timeline for that, where you have to advertise, you have to post notice, you have to do your best to try to get a hold of them. And then when all of that expires, then you can abandon, you can, sell the items, or if there's anything of value, you can sell it, or you've got to try to re-rent your unit. I mean, that's ultimately, as a landlord, you're trying to get things emptied, you're trying to get things re-rented as quickly as possible, but now, you've got these abandoned items in the way. So it doesn't have any timelines is what I'm seeing here, but we're just getting started in this. So this is also interesting. Action in ejectment, claims for arrears of rent, double rent, and waste. This is interesting because I've never seen something for double rent. It says, if judgment for possession be rendered in favor of the plaintiff, meaning if a landlord sues a tenant to get out and they win, the landlord wins, shall be entitled at the same time to a judgment for said arrears of rent and for said double rent, as the case may be, the date of verdict or judgment, and for damages of waste. So basically you can recover anything that has been wrecked, and back rent looks like ×2. Interesting. And there's a bunch of different things. You can do a lien, enforcing a lien. Okay, let's keep going. Let's go to the next one. So that one is Code Counsel for Washington, D.C. This one is also Code Counsel, but it is Chapter 35. This one was Chapter 42. It says Chapter 32, Landlord and Tenant, but the statute says 42. That's kind of weird. Okay, and then this one says Chapter 35, and the statute again says 42. So I'm not really sure how their pagination is, but I like saying that word, pagination. Okay, so rental housing generally, this is Chapter 35. So the hyperlink from the other side went to here. And so, this is really interesting. This has got a lot of good stuff in it. So it's got rent stabilization, tenant assistance, evictions, retaliatory action, which we need to look into, payment of rent beyond 5 days after due date, conversions. I'm just going to scroll down here because this is kind of different. Okay, low, moderate priced housing. Well, I really like that whole idea of cross-referencing that section. So in this case, there's the cross-referencing just of the housing shortage, and then they're talking about cross-referencing real property tax assignment, tenant protection revisions, rental housing conversion. It's kind of cool that they kind of say, hey, by the way, this is related. And then they give you the hyperlink to that too. So there's a bunch of definitions. That's normal. And when I see these tenancy laws, that's really a good thing, because not all terms are the same in every one. Annual fair market rental amount means the annual sum of rents collected for all rental units in the housing accommodation during the base calculation year, plus the increase for the consumer price index. Interesting. Okay. Apartment involvement program's got a bunch of them, and it's alphabetical. I've seen quite a few of these where they're not alphabetical, which is very strange, and trying to find something doesn't make sense. But this one is alphabetical. That's good. talking about property taxes. What does that all mean? Rental accommodations, rent surcharge, substantial violation, substantial rehabilitation. Okay, interesting. Okay, and I'm just scrolling through here. Rent stabilization program. I'm not going to say yeah, there is a rent stabilization, a rental housing commission in Washington, D.C. And looks like they work for the mayor in, let's see what they do. Rental Housing Commission, Rental Housing Act. Looks like they help deal with all of these laws, which is kind of cool. Okay, so it goes into detail. Now remember, we're still in the law part of this. We haven't got into any of the user guides or anything from any of the tenant-based, landlord-based rental housing stuff that's helpful. This is just really still legalese, which is normal. You know, that's normal when you look at any of these location-specific episodes that I do. This is kind of where you start. Emergency legislation, temporary legislation. Okay, this is talking a lot about, okay, this is really long. Let me go all the way through this. I probably should go back up. Let me go back up to the hyperlinks at the top. Payment of rent beyond 5 days after due date. That's something that we can talk about. Let's go there. Okay, authorized fee for payment of rent beyond 5 days after rent payment is due. So it's saying the housing provider may charge a late fee of no more than 5% of the full amount rent due by a tenant. Housing provider may only charge a late fee if the written lease agreement between the housing provider and the tenant informs the tenant of the maximum amount of the late fee. That's true. If the tenant has not paid the full amount of rent within 5 days or longer grace period that may be provided in the lease after that day the rent payment is due, but the housing provider shall not charge interest on the late fee, deduct any amount late fee from subsequent late rent payment, impose a late fee more than one time on each late payment, and evict a tenant on the basis of the non-payment of the fee itself, the late fee. Yeah, so it looks like the grace period is 5 days before the late fee is due. Okay. Well, that answers one of the questions. Okay, let's keep going. So the hyperlink for the next one is the Office of the Tenant Advocate. And so this is the third link in the show notes, and it's got the Tenant Bill of Rights, and it's got it in like 8 different languages. So I'm just going to click English because that's probably easiest. It's only 4 pages. So this is actually really simple, very, very user friendly. And I really like it when locations do this. So especially when it's so short, like it's almost like a brochure that you can do. So, and of course, it's got the normal thing on it. It says this document is not exhausted and is intended to provide tenants with an overview of basic rights. Except for rent control, all of these rights apply to every tenant in the district. Now, we'll talk about rent control as we get through this, but it's talked lease. A written lease in Washington, D.C. is not required to establish a tenancy. Now, you will, if you are a longtime listener of this show, you will know that I push to have everything in writing, including a lease. So even though it's not required in Washington, D.C., it is highly advised. It is definitely best practice. So if there is a written lease, the landlord must provide a copy of the lease and all addendums, and also must provide copies of district housing regulations, including those for landlord and tenant relations. And the landlord may not change the terms of your lease without your agreement. And after the initial lease term expires, you have the right to continue your tenancy month to month indefinitely on the same terms, except for lawful rent increases. So there it is. So it does not, leases do not end abruptly. Fixed leases, let's say you rent for a year, it automatically converts. And so it will automatically, it does not end abruptly. You will not see a holdover in this at all because it just said it right in here, it automatically converts. Okay, security deposit. The amount of security deposit may not exceed the amount of 1 month's rent. Landlord must place your security deposit in an interest-bearing account and post notices saying where the security deposit is held and the prevailing interest rate. If there is a move-out inspection, the landlord must notify you of the date and time. Within 45 days of your vacating the apartment, the landlord must either return your security deposit with interest or provide you with written notice that the security deposit will be used to defray legitimate expenses, which must be itemized within 30 more days. Okay. So if you're going to keep a security deposit, you've got to do a move in, you've got to do a move out inspection, and that's got to be written. Yes, pictures are good, but make sure you've got it written. And I don't know if they have pre-made forms in Washington, D.C., but if they don't, there's plenty of places that you can get a condition inspection checklist for both move in and move out to help. And of course, again, pictures help. Okay, disclosure of information. Upon receiving your application to lease an apartment, landlord must disclose the applicable rent for the rental unit, any pending petition that could affect the rent if rent control applies, any surcharges on the rent and the day they expire if rent control applies, if rent control or exempt status of the accommodation applies, certain housing code violation reports, the amount of any non-refundable application fee, security deposit, and interest rate, any pending condo or co-op conversion, ownership and business license information, and either a 3-year history of mold contamination as defined in the unit and common areas or proof of proper remediation, and a copy of this BC Tenant Bill of Rights document. Interesting. The landlord must make this information accessible throughout your tenancy, and upon a tenant's request once a year, the landlord must disclose the amount of and the basis for each rent increase for the prior 3 years. Okay, I got it. Receipts for rental payments. The landlord must provide you with a receipt for any money paid except where payment is made by personal check and is in full satisfaction of all amounts due. Meaning if you are late in rent and you're not paying everything for due, especially if you're paying with your personal check, your canceled check is very likely your receipt. The receipt must state the purpose and the date of the payment as well as any money that remains due. So you basically need a statement of account is what this is for. Okay, rent increases. Let's talk about this. Rent control limits the amount and the frequency of rent increases. For units that are exempt from rent control, generally only the lease terms limit rent increases. Okay, if rent control applies, landlord may not raise the rent unless the owner and manager are properly licensed and registered, unless the unit and common areas are substantially complying with housing code. More frequently, you cannot more frequently than once every 12 months, so once a year. You cannot raise it more than the consumer price index for an elderly tenant 62 or over, or a tenant with disability, regardless of income, if registered with the rent administrator. And you cannot raise it by more than consumer price index plus 2% for all other tenants. I suspect this is probably advertised or somewhere that's quite conspicuous for landlords. A rent increase larger than either of those two with a consumer price index requires government approval of a landlord petition, which tenants may challenge. You can also challenge rent increase implemented within the prior 3 years. Okay, building conditions. Landlord must ensure that your unit and all common areas are safe and sanitary as the first day of your tenancy, and this is known as a warrant of habitability. And that must include compliance with the housing code, including keeping the premises safe and secure, free of rodents and pests, keeping the structure and facilities of the building in good repair, ensure adequate heating, lighting, and ventilation. And the tenant has the right to receive a copy of the notice of violation issued to the landlord if applicable. Okay, lead paint hazard. Now, this is a federal thing. They throw it in here as well. It's Washington, D.C., so it still is applicable, but this is federal. So for properties built prior to 1978, the landlord must provide a prospective tenant household with a form issued by the District Department of Environment about their rights under the D.C. lead laws. And then there's other ones. I'm not going to read all about the lead paint, but just know there's lead paint. There's also mold, information about a mold. So upon written notice from a tenant that mold or suspected mold exists within the unit or common area, the landlord must inspect the premises within 7 days and remediate within 30. Mold assessment and remediation must be performed in compliance with district regulations. And if you are in this situation where you've got mold reported, this could be a little bit difficult because you've got to inspect within 7 days, remediate within 30. Well, what happens if you don't have a contractor that's available within 30 days? You've got to show that you're actually trying to keep up with this, right? Pretty important. Quiet enjoyment and retaliation. Okay, this is definitely something we need to make sure that we are clear about. This is 2 points that they actually put together that I don't think should be put together, but still. Landlord may not unreasonably interfere with the tenant's comfort, safety, or enjoyment of a rental. So you cannot have abuse of access, whether for the purpose of causing housing accommodation to become vacant or otherwise. Also, the landlord may not retaliate against you as the tenant for exercising any right of tenancy, including unlawfully seeking recovering possession of your unit, increased rent, decreased services, or increased obligations, and also includes violating your privacy, harassing you, or refusing to honor your lease. And it does not have a timeline in here. Usually when landlord retaliation is defined, there is a timeline, and that is not there. So this will be interesting. So it talks too about discrimination, right to organize as in a tenant association or tenants union, sale and conversion. Tenants must be given the opportunity to purchase an accommodation before the landlord sells or demolishes and discontinues the housing use. The landlord may not convert the rental to a co-op or condominium unless the majority of the tenants vote for conversion in a tenant election. And that's got to be done properly. Location assistance, relocation assistance. If you are displaced by alterations or renovations, substantial rehabilitation, demolition, or discontinuance of the housing use, you may have the right to receive relocation assistance from your landlord. I know there's lots of other places where that is the case. Eviction. If your landlord may evict you for one of 10 specific reasons set forth in Title V of Rental Housing Act of 1985. For example, you may not be evicted just because your lease term expires or because the rental property has been sold or foreclosed, because that just is a change in ownership. Even if there is valid basis to evict you, the landlord may not use self-help methods to do so, such as cutting your utilities or changing the locks. That is illegal. Landlords don't do that. Rather, the landlord must go through the judicial process, and generally the tenant must be given a written notice to vacate, an opportunity to cure the lease violation if that is the basis for action, and an opportunity to challenge the landlord's claim in court. Finally, any eviction must be pursuant to a court order and must be scheduled and supervised by U.S. Marshal Service. Okay. And then at the end of this document, there are 4 locations that four websites and phone numbers. There's all kinds. So you've got the DC Department of Housing and Community Development, the DC Office of Tenant Advocate, the DC Department of Consumer and Regulatory Affairs, and the District Department of Environment. And so, and actually this is set up so that the tenants can sign this. So that's cool. But you've got your resources right here. You're starting to get a bunch of resources. So it's at least it's 3 pages and then all the resources on the back. All right, let's go to the next hyperlink. So this is a bit of a presentation that looks like 2 gentlemen did. Tenant rights and responsibilities in District of Columbia. So basic DC on law, evictions, non-payment of rent. So this is the basis of eviction for tenants in DC, non-payment of rent, and then violation of obligation of tenancy. Basically, they're misbehaving. Court determines that a tenant or occupant has performed an illegal act. Personal use of the owner. So you've got to give 90 days notice for that. Contract of purchaser's personal use and occupancy, meaning the building or the property is getting sold and the buyer wants to move into the unit. So they still have to give 90 days. And then alteration and renovations that cannot safely be made while units are occupied. And that must include temporary relocation, not permanent eviction. And you still have to give 120-day notice for that. If you're demolishing the unit, so valid basis for eviction. Now I have to say this, eviction, in my world, eviction means that the tenant has done something wrong and they are getting displaced because they've done something wrong. If the unit is getting demolished, or if we go back a slide and say that the owner is personally using it, the contractor, the buyer is going to personally use it, the tenant has not done anything wrong. And so I would not call this an eviction. I would call this an end of tenancy, right? You're ending tenancy with all this notice because of this. And same thing, substantial rehabilitation, 120-day notice, discontinuation of housing use, 180-day notice, and conversion to condo or co-op, 90-day notice. None of this is the tenant's fault. And so I would not say this is an eviction. I would say it's an end of tenancy. And this slide is, it's funny, it's as important. Foreclosure is not a valid basis to evict a tenant in the District of Columbia. And the reason that is actually true in most places, because a foreclosure is simply a change in ownership. Does not mean just because a property shifts owners does not mean that you're going to be able to out everybody. That doesn't work like that. So following foreclosure, most likely grounds for eviction. I think this is all talking about shifting after foreclosure, foreclosing deed, new landlords, change in management, but the leases shift around, right? Rent control, this talks about the consumer price index for the different tenants. So 2% over the consumer price index for all of the tenants that are not considered elderly and disabled over 62 years old. So for units that are not under rent control, the only limits on the amount or frequency of the rent increases are those agreed to in the lease or otherwise. So there is very likely, if you are a landlord in Washington, D.C., and you're wondering how much you can raise your rent and you're not under rent control, then that's probably a really good question for Office of the Tenant Advocate. They would probably be able to guide you a little bit more. And there's some other resources coming up, but that's actually a really good question because there probably is wording. I'm certain there's wording in there about what is it that you can actually increase it. There's very likely a percentage amount. Okay, Tenant Opportunity to Purchase Act. Generally in DC, a tenant has a right to purchase a rental unit that is put up for sale. And what to do if you receive a notice to vacate or any other foreclosure notice. Let the new owner or whoever sent you the notice know that you're a tenant in the property, especially it's from a bank or an attorney. So this is a very somber thing, this whole thing, but there it is. And then it's talking about what do you do if you receive a court summons? And it's pretty simple. If you receive a court summons, then you need to go to court on that date. What do you do if you receive a notice to vacate or any other foreclosure notice? And then it gave you a whole bunch of phone numbers here. So you can call Legal Aid Society, DC Law Students in Court. Yeah, there's several others. And of course, there is DC Office of the Tenant Advocate. There it is, Legal Aid Society. In fact, I don't think I've put the Washington, DC Legal Aid Society housing. I'm going to put that on there because I suspect that's in there. And if it is, I will add that into my hyperlinks. So housing law, our work for tenants. So here it is. So I'm going to put this in as one of the hyperlinks in the in the show notes so that you can see this too. So this is where legalaidDC.org talks about eviction, housing subsidies, conditions, rent increases, and landlord tenant legal assistant network hotline. And so this is a phone number you can call. I mean, there's just resources all over the place. It's pretty incredible. And then there's one that says request help, housing right to counsel. Let's see, housing vouchers, tenant representation. So of course this is skewed to the tenants, I get it, but that's okay. You can still have lots of resources that landlords can use as well. And like I'm both a tenant and a landlord. So it goes all the way around. Okay, so that was that one. Let's go to the next one. So this is the Office of the Attorney General for the District of Columbia. Again, this is the resources for tenants. And these websites start to cross into each other at this point. And so you've got legal help. There's a bunch of hyperlinks here. And so you can know your rights. Copy of the Bill of Rights from the Office of the Tenant Advocate website. That's just where we were. We were just there. And they're talking about document and report problems, keep a notebook or a diary, of course. And that is true regardless if you're a tenant, landlord, business owner, whatever, you want to keep some kind of a written log of some kind, even if you send yourself an email, just something to note that it is, and it's basically date time stamped. And especially if you have to give that notice to someone else to show that you've actually given them properly, notification that something is wrong, or you're giving a warning letter to a tenant, same thing, you'd want to date them and you want to date the letter and show that it's in. And so they're giving you sample diary entries. That's kind of cool. Request a housing code inspection from Department of Buildings. You can do that. And they have a quick housing code checklist. Let's look at that for a sec. That's kind of cool. Oh, cool. So this is their checklist that they use. And it's just a one-pager. Roofing, gutters, and downspouts maintained. Exposed exterior wood surfaces not being kept painted. Exterior wall has missing parts. Exterior wall has cracks. Okay. Wall has cracks, ceilings, dampness. Yeah, you don't want any wetness or holes. Door has defective hardware. Oh goodness. Kitchen, bathroom, refrigerator's is not in good working condition. Refrigerator has defective or missing parts. Cooking facility has missing parts. Goodness sakes, I would not want to live anywhere that there was no smoke detectors or central heating or this is kind of sad. I'm going to add this one in as well so that you can see it. DCRA communications code checklist. Okay, I'm going to go back to this one. So then this talks about Department of Buildings Inspection and Compliance Administration. It talks about dealing with mold, legal help. There's actually even more legal services, neighborhood legal services. Let's open this one. Let's see what it says. So that's the checklist. Okay, let's go to this one. Free legal help. Oh, and it's talking about different intakes and who you are, intake website, apply for help, calling, the number to call, and then upcoming events. This is great. This is actually really great. Fantastic. Resource Center, representing yourself. Oh, and there's tons more assets. My goodness. Lots and lots of things. Housing law, consumer law, domestic violence, public benefits, employment sheets. More housing. Oh, interactive tools for filling out common landlord tenant forms. Let's go there. So this is lawhelp.org/DC. And so this one, oh, this is a motion to allow service by publication or posting, including absent defendant locator worksheet. I'm not sure this is going to be super helpful. I'm not sure I'm going to add that. It's there. I wish there was more to it, but there's there. Okay, let's keep going. So this one is the University of District Columbia David A. Clark School of Law, and this was the housing. They did a housing clinic about this. And so this is just an article that I threw in. I thought that was actually really interesting about housing and housing cooperatives, entrepreneurial support for all kinds of different aspects of people supporting and creating housing. So this is from 2023, but anyway, you might find this interesting. So I threw it in. Okay, oh, this is Legal Aid Society, and I've already put this one in. Okay, so I think we've done it all. I'm going to stop sharing for the moment. If we come across something when I'm going through the bingo card, I will jump back into screen share and we'll search for it. But I think we've hit a lot of these, which is kind of interesting. So let's talk about this. Okay, here's my bingo card. Tenant application fee. Didn't say anything about a tenant application fee, but it did say that if non-refundable fees were listed, that you actually had to declare it when someone applied. Didn't see that. I'm not going to take it at the moment. Grace period for late rent without a penalty. Yes, we saw that, 5 days. Late fee amount is up to 5%, and you must declare that in the lease. Security deposit method must be in an interest-bearing account, but it didn't say where. It didn't say location, didn't say any of that. Other places say that it's very specific, but it just said interest-bearing. Lease wording and details. Didn't say anything about specifics of the lease. It did not give you an example of a lease. Okay, that's all right. It just says it could be written. I highly suggest that it's written. Is an emergency contact required in the event of tenant abandonment, incapacitation, death, or imprisonment? Doesn't talk about that at all. But again, best practice, knowing that we have an aging tenant population. So make sure that you have an emergency contact of some kind. Pets and animals. Didn't talk at all about pets or animals, pet deposit or pet rent at all. Delivery of signed lease required. It did say that not only was the lease required, you had to give them all kinds of other documents, including the Bill of Rights for the tenants. You've got to give it all, but it didn't give you a timeline, right? Like some places you have to say you have X amount of days. It didn't say that. It just said you had to give it to them. Condition inspection at move-in. It was not stated, but if you keep a security deposit, then you need to do a condition inspection at move-in, and you also need to do one at move-out. It did talk about the one at move-out, though. Standard warning letters or wording. No. Didn't see that, not in the locations that I saw, but there were some diary entries, some different mock diary entries of different things. And so it's kind of templated, kind of. How often can the rent be increased? Looks like once a year. And then what is proper notice on a rent increase? It depends. Actually, they didn't talk about the notice of rent increase. They just talked about how much it can be increased if you're in rent control and if you're not in rent control. We talked about not rent control. Yeah, but it didn't give the proper notice on the rent increase. Interesting. Okay. Renter's insurance was not mentioned. Abusive access was defined, as was landlord retaliation. End of fixed lease automatically converts to periodic. Condition inspection at move out was discussed. Return of deposit timing was discussed. 45 days, and if you were going to take parts of that deposit out, you had to give line item explanations. And can you use deposit as last month's rent? Yes or no? Did not say, which means probably no, but a lot of people get confused about that because it's all money, but it's not in the same bucket, right? The deposit is, it's the tenant's money, not rent money. How long can you give until notice of eviction for non-payment of rent and utilities, notice of eviction due to mischief? Looks like 30 days on all of it. How long until you can get possession of unit? It looks like it's about 30 days, as fast as you can give notice. But then again, it depends on what you're going to be evicting them for. And then abandoned items, does it know value of items, administrative, inventory requirements, storage timing, disposition instructions? It doesn't say that. It just says if you get possession of the unit and you change the locks with the marshals, then you get all the items inside, and that's it. So interesting. That's a little more abrupt than I'm used to seeing. But that's my bingo card. So that'll at least get you a running start with your rentals in Washington, D.C. Each of my location-specific podcasts is set up in the exact same way, answering the same 4 questions. What are the basics of that location tenancy law? What are the nuances of that location? What's different? Some guidance about abandoned items left behind by a tenant and where to get help in your local real estate district or province. And then I reviewed my bingo card of standard items I most see often in tenancy laws in these different locations. And this is the same format in every location-specific episode. So if you're interested in another geographic location, or you're just curious, you already know what I'm going to talk about just in a different location. One more time, though, this episode is not all-inclusive. You must research your own further research items in your own specific area to be most current in your specific area where your rentals are. Not where you are, where your rentals are. This is really important. So today's episode is designed to get you started. Now, if you're listening to this podcast, chances are you're either new to real estate or you have real estate in Washington, D.C. Things you can do to help yourself is, 1, read all of these resources that I've brought up. Do your homework and make sure that you are getting all of the information, especially stuff that's changing. This is really important. Tenant Bill of Rights, but there are other items that you can read as well. And the second thing is you want to get in the same room as other landlords in your area. So check out your local meetup group within Washington, D.C. And how do you find those, you might ask? You can jump on social media. You can also do meetups online, but you want to get in the same room, whether even a virtual room, with other landlords from Washington, D.C., so that the local folks asking questions like you are, you can hear their answers. You can hear some of the OGs in the Washington, D.C. area talk to you about their rentals. I hope you enjoyed today's show all about Washington, D.C. Don't forget to subscribe for more expert advice and real stories from across the rental property world. I'm recording this episode today in Maui, Hawaii, where it is raining sideways right outside. Why? Because real estate takes you places. Where do you want real estate to take you? Join me in the next episode live right now in the library, episode 194 about South Carolina. I'll see you there.